Utah's legislature prepared for the day the Supreme Court might return abortion rights to the states. They passed a bill in 2020 that gives Utah a trigger law.
KSL investigator Daniela Rivera joins us now to break down that trigger law and what it will mean for abortion access going forward. Daniela.
Utah's trigger law was crafted to send a message.
We wanted to put a stake in the ground and say, hey, Supreme Court and others across the United States, where would Utah be?
Senator Daniel McKay sponsored the legislation that's been ready and waiting for 2 years now.
There would be a ban on elective abortions.
Senate Bill 174 does not apply to procedures after a miscarriage or an ectopic pregnancy. It bans abortion in all cases, except when necessary to prevent death or serious risk of substantial and irreversible impairment of a major bodily function of the mother, cases of rape and incest that have been reported to law enforcement, and a uniformly diagnosable and lethal defect or brain abnormality in the fetus. Physicians who provide abortions outside of these restrictions can face felony criminal charges.
I'm sure if there was a poll of unborn children as to whether or not they'd want to live, I think, now, unfortunately, they can't speak for themselves. So I think in this situation, the law has to step in and speak for them.
Medical and legal experts have concerns about putting the law into practice.
It was hastily passed, and we've got a lot of figuring out how to make it work.
It seems to have kind of started and ended from a place of moral outrage and not thinking through the policy implications.
Tennille Brown, a professor at the University of Utah who specializes in health law, and Carrie Galloway, CEO of Planned Parenthood in Utah, say too much of the language in this legislation is undefined and at odds with real medical terms. They point to phrases like irreversible impairment and uniformly diagnosable.
If you're going to allow healthcare providers to interpret the law, I have to tell you it's going to be different than how the legislators who made the law think it should be interpreted.
The law here is very absolute, certainty, uniformly diagnosable. That's not the way medicine works. That's not the way our bodies work. Everything exists on a spectrum.
And my guess is sometimes these things are going to end up in court.
I rise in opposition to this bill, and I rise as a healthcare medical physician.
Their concerns echo those of Draper Democrat Representative Suzanne Harrison during debate on the House floor.
For us to be putting in statute political gobbledygook as a medical requirement for a diagnosis that two physicians have to sign under penalty of medical legal liability is dangerous.
Are there things in this legislation that are problematic?
It's always hard trying to find the right balance in these things. The legislature meets every year for a reason, because we're constantly revisiting policy.